Na mtazamaji, basi chama cha kutetea ama shirika la kutetea haki za kibinadamu humu nchini pamoja pia na chama cha mawakili humu nchini wanatoa taarifa kuhusiana na masaibu ambayo yamekuwa kimkumba Miguna Miguna. Hebu tuwasikize.
We are reliably informed that Mr. Miguna was redeported last night aboard flight EK722. Sources confirm that he was quietly seated on seat number 45J when the flight took off from Nairobi. KNCHR team was on the ground all along until this time. It is left for people's imagination on how the authorities got Mr. Miguna to be quiet and compliant. The botched re-deportation attempt on Monday, 26th March, was a most unfortunate event that has exposed Kenya to global ridicule. The legal fraternity and the whole country has become increasingly concerned with states' blatant disregard of lawful court orders as witnessed over the last couple of months. Our constitution outlines that the authority of the people shall be exercised through the three arms of government, the executive, legislature, and the judiciary, which ought to be independent so as to offer checks and balances. The national values and principles of governance requires that the rule of law be the center of the nation. Indeed, laws emanating from Parliament and the judiciary through orders of court must be obeyed. Organs that have been created by the same constitution must adhere to the spirit of the constitution and not undermine each other. It is clear that in this case, our judicial arm of government is besieged by the executive through commissions established by the Constitution and appurtenant legislations. The present circumstances are telling, a manifestation of such disregard of the law and orders of court. We, the legal profession, are concerned with the handling of a Kenyan citizen and an advocate of the High Court of Kenya, Mr. Miguna Miguna. In blatant disregard of court order by Justice Kimaru, Mr. Miguna was irregularly deported. The court ordered his return, but he was held incommunicado with no clear reasons and explanation. The order of court preferred on the 26th of February 2018 gave several options to the parties to effect Mr. Miguna's safe re-entry into the country. One of them being the option to use his Canadian passport to secure re-entry into the country. However, we understand that Mr. Miguna had concerns about handing over his passport, being his only travel document. At this point, the state ought to have exploited the alternative means for securing his entry into the country, avert the unfolding saga that is being witnessed at our doorsteps. It is very clear that the government had not taken any measures to secure Mr. Miguna's entry into the country, as had been directed by the court on the 26th February 2018. This notwithstanding, the state has continued to disregard subsequent court orders relating to release, handling, and entry of Mr. Miguna. The order by Lady Justice Aburili, issued on the 27th March 2018, was ignored and disregarded. Further, on the 28th of March 2018, the High Court issued 3 more orders, one of them requiring that CS Interior Fred Matiang'i, the IG Joseph Boynet, and Director of Immigration Gordon Kihalangwa to appear in court. This too was disregarded. Court orders to produce Miguna in court were also ignored. It is important to remember that there can be no justification for disobedience of court orders by any party. There is no reason lawyers should be attacked while lawfully executing their mandate. No entity, be it the state or private sector, has the liberty to determine which orders is convenient to obey. And if the state is disgruntled about an order, there are options of seeking to set aside the order or appeal. We call upon the government to lead by example and to respect